That's contrasted, Your Honor, against the court regularly, apparently, ruling on motions that directly benefit the Commonwealth. Like when the court immediately ruled from the bench and granted 2 motions to quash subpoenas that favored Brian Albert and Jennifer McCabe. For those records, there was no delay. For that request, or a series of requests.
Hold on a second.
Please turn off your audio.
Go ahead, Mr. Jackson.
Best laid plans.
If you started paying attention to the Karen Reed case when the trial began, let me catch you up. The defense endured nearly 2 years of inexplicable delays and were prevented from examining crucial physical evidence by the Commonwealth. This was coupled with the court's refusal to assign deadlines, a set of circumstances once purportedly described by Karen Reed as a game of hide the football.
For the request that I just mentioned about the quashal motions, there was no delay by this court. The court made the rulings from the bench, and that made the public, in public commentary, question the court's motives. In fact, the court has unilaterally sought to even advance certain motions that the Commonwealth has presented. May I?
Try again.
If this seems more like a circus to you than a court of law, you are not alone. Judge Cannoni's courtroom has been the center of controversy before. In fact, only 10 days prior, this happened.
Your service is complete. I'm declaring a mistrial.
A job is left unfinished. It leaves a really bad taste in your mouth, really bad feeling.
2 days after the murder trial of Weymouth Sergeant Michael Chesna and 77-year-old Vera Adams was declared a mistrial, we're hearing from Cindy Lavoie, who was the foreperson of that jury that could not reach a unanimous decision.
We don't want a mistrial. That was the #1 thing.
Lavoie says when the jury first started their deliberations, there was an even split, but that eventually more jurors came to an agreement that Emmanuel Lopes was guilty. However, Lavoie says there was one juror who agreed with the defense's argument that Lopes was having a psychotic episode and was not legally responsible for the murders, and that the juror completely shut down and would not engage in any conversations.
When somebody just doesn't want to participate and doesn't want to show you the information, how they got to a certain conclusion, it was so frustrating.
Your service is complete. I'm declaring a mistrial.
Lavoie says it was gut-wrenching watching Sergeant Chesna and Vera Adams' family react to the news in the courtroom. That uneasiness only continuing once the jury was loaded onto the bus to head home for the final time.
And on that bus ride home, no one said a word. We were all just in our own heads and just deflated.
Quoting Turtleboy Daily News, a judge should never allow someone to disrespect their court like that. If this juror was too emotionally immature to handle a murder case without breaking down, then she should have been replaced. There were 2 more alternates available. Now, let's jump back to the motion to recuse.
The court has unilaterally sought to advance motions that have been advanced by the Commonwealth while still not ruling on motions that we've had before the bench for not just days or weeks, but now months. And it's the disparity in that treatment.
Alan Jackson is calling out the court on her apparent bias in taking months to rule on defense motions, and only ruling from the bench when it benefits the Commonwealth. This would be consistent with the idea that the state aims to bleed Karen Reed dry of funds in order to force a plea. Karen hails from a squarely middle-class family, and they have poured every resource they have into funding her defense because they know she's innocent. Each time worksman Jackson Quinn fly in from California to attend a hearing, the cost falls on Karen. She has assembled a top-notch legal team, including an audio-visual engineer and a 3D graphics expert. But quality defense doesn't come cheap. The Commonwealth is fully aware that every delay in the proceedings drains Karen's financial resources even further. Let us briefly jump ahead a few months in time, where attorney Elizabeth Little eloquently demonstrates the dirty tricks played by the Commonwealth.
Quote, "The prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference." Our first pretrial conference was on August 12, 2022. The compliance date for mandatory defense access to this physical evidence was more than a year ago. So when Mr. Lally stands up, as I believe he probably will, and says, "We're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote, "I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in discovery about a month ago, this is what you see. Quote, "Note to file, date January 3rd, 2023. Entry by John Buello. Person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report." And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception.
This was the exact moment I knew that Lally wasn't simply incompetent. He was complicit.
Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention.
That intervention never came. This judge refused to impose deadlines on the Commonwealth, allowing them to stall for years in providing evidence that normally takes weeks. Now, let's jump back to the motion to recuse.
Look, I don't disregard the fact that the court is a very busy court, that the court is a supervising court. The court has a lot of balls in the air. It's the disparity between the court's rulings in terms of the Commonwealth's motions and the defense motions that I think give the public pause, and that's where we need to start our analysis. Number two, the court seems to have deviated from the normal course of procedure, in this case, in order to specifically stay on the Karen Reed case. And the court only made that known, or at least known to us, to the defense, after the Commonwealth filed a request to gag the defense. The optic is that the court had or has a personal interest in ruling on that particular gag motion, which is on calendar today, and wants to keep control over this case. That move has also prompted the public to raise questions about the court's fairness. Why is that happening? Why is that happening? Why is that happening? Why is that happening? And it has eroded public confidence in this system, at least insofar as this case is concerned.
The benefits of rotating judges include promoting fairness and objectivity in the judiciary, as it reduces the risk of entrenched biases or conflicts of interest. The purpose of this practice is to prevent any one judge from developing undue familiarity toward a particular set of individuals. However, this judge decided to ignore the schedule and stay on the Reed case, even though she was to rotate off in July of 2023. The factors that led to this decision are a mystery, since no explanation was ever given. And as Alan Jackson just stated, it did appear to the public at the time that she extended her stay in order to rule on the Commonwealth's motion to gag the defense team. In fairness, she did ultimately deny that order. But would she have if the defense hadn't called her out?
Number three, the court outright denied Ms. Reed a full and fair opportunity to be heard, if the court recalls, the last time we were here on a critical Rule 17 motion.
Regardless of whether or not defense counsel and the Commonwealth agreed to an evidentiary hearing, there's no authority for it. I am not having an evidentiary hearing in this case.
Of course there's authority.
No. I am not having an evidentiary hearing.
I mean, Gemma Cabe is the most important witness to this case. She was subpoenaed by the defense, and they're going to grill her. She would take the stand, and she would get ripped apart, probably get herself charged with murder herself. He can't let that happen, so he's filing this motion to quash. He wants to prevent that from happening. And they filed these motions 2 days before the hearing. Gemma Cabe was subpoenaed 2 weeks ago. She waited until now when Alan Jackson and Elizabeth Little are in the air, flying in at Karen Reed's expense. And I guess he didn't think that they might bring these guys in. And so you're the one that said we could do this.
So there will not be an evidentiary hearing on a Rule 17 motion. I will hear you, even though the Commonwealth says that this is a regurgitation of the first motion.
May 3rd, all parties agreed to an evidentiary hearing and schedule it for May 25th. The defense orders witnesses to testify, including Jennifer McCabe, Brian Albert, Troopers Proctor, and Guareno. The Commonwealth realizes exactly how treacherous it would be to have these 4 unprepared witnesses testify at such an early stage of the cover-up. On May 23rd, 2 days before the evidentiary hearing, the Commonwealth files motions to prevent it all from happening. An emergency hearing is scheduled for the next day, May 24th. This brings us to the present situation. Judge Cannoni has just informed the defense team that despite prior agreement, the evidentiary hearing will not take place. What makes this especially suspicious is the judge's decision to cancel a scheduled hearing so close to the date, and allowing the Commonwealth to make such disruptive last-minute moves. Adding to the concern is her absolute refusal to discuss the matter with the defense. She is adamant that no evidentiary hearing will take place. For a judge who typically takes everything under advisement, she made a series of unusually swift decisions that likely spared the Commonwealth from disastrous consequences.
I will hear you on the Rule 17 motion now. So, Mr. Jackson, I'll hear you on your Rule 17 motion.
Your Honor, with regard to the Rule 17, very clearly, this is not, as the court just indicated, a regurgitation of anything. It's a brand new motion.
Watch closely here as Alan Jackson is uncharacteristically speechless, stunned by what he's just heard this judge say in open court. Remember, Jackson himself has decades of experience as a prosecutor. Judge Cannoni is kind enough to hear him argue his motion, despite the Commonwealth's claim that it's simply a regurgitation of one that came previously. If anyone can sense the rot of corruption, it's Alan Jackson. I can only imagine what he's thinking in this moment. Regardless, he's not ready to let this go just yet.
I understand and respect the court's ruling. I am confused, and I must say I don't quite understand the court's ruling, given the fact that the Commonwealth has taken such a vigorous position in their affidavit on the facts that are averred in our Rule 17 motion. It seems to me that would be the perfect opportunity, even if it's limited to the experts on the issue of the Google search.
Okay, so I understand, Mr. Jackson, that you wanted an evidentiary hearing. There will not be one.
She absolutely will not allow it to happen under any circumstances. It feels like she did someone a very big favor.
our question would be, what is the Commonwealth so desperately afraid of?
It's not unusual for record holders to oppose motions for their data. They have their right to privacy. However, the Commonwealth has also joined in opposing those motions. What possible interest could the state of Massachusetts have in keeping Brian, Albert, and Jen McCabe's phone records private? They are witnesses in a murder trial. So why do they care? The state's role should be to seek truth and justice. Withholding records in no way advances that goal. Jackson is skillfully taking this opportunity to question their motives.
Why are they so desperately afraid of us getting the materials, the documents, the data, and the physical phone that we've sought, respectively, under the Rule 17 motion for Brian Albert's phone and the data associated therewith for Jennifer McCabe's cell phone data as it pertains to the cell records? What are they afraid of? They seem to be desperately fearful that we're actually going to get to the truth of what actually happened.
Now, let's jump back to the motion to recuse.
And that brings me to the final point and dovetails into that final point. Sean McCabe, a member of the McCabe family and a brother-in-law of Jennifer McCabe, whom we have argued in this court, should have at least been a suspect. Or
You're going to show that this way, Ms. Little. Why don't you show it to me? Thank you.
By the way, Judge Beverly Cannoni does not like when the defense shows chalks. We'll jump ahead briefly to view another example.
For those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any... If you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail argument? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the appropriate time.
I don't need to see a chalk, Mr. Yannetti.
And now back to the motion to recuse.
Sean McCabe made a claim to a reporter in public, claiming to have a personal relationship with this court. And he tried to prove it by citing to the fact that Sean McCabe knows personal information about the judge, which is extremely troubling, about a beach home, not just the fact that the court may own one, but exactly where it is. And his words were, after Sean McCabe's words were, after receiving a question from the reporter, do you really have a line to Judge Cannoni? His answer was, Auntie Bev, and I mean no disrespect, I'm quoting, Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under?
Where he says, I just called in an order asking Judge Bev to institute a trial by combat order against you. It is weird that this guy is just throwing around her name like that days after a hearing that was very favorable to his sister-in-law, that prevented her from taking the stand and answering why she Googled this at 2:27 a.m. She never had to do that. And that's odd that this guy is all of a sudden acting like she's on Team McCabe. That's interesting. And I go, do you really have a line to her? And he goes, Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under? And indeed, she does have a house in Centerville, in part of Barnstable. So that's interesting. How does he know that?
Extremely troublesome dialogue, but it's not just the threat that's inherent in the dialogue. That's on one level. It's the fact that this person claimed to know that this court may own a beachside cottage somewhere. Your Honor, I will say I've appeared before hundreds. At this point, I'm getting old. I may have appeared before thousands of judges in my nearly 30-year career. I've never, ever known where a single one of them has ever lived or property that they may or may not have owned. But Sean McCabe appears to know, and he appears to intimate that he knows the details of this court's personal life. And it was his family that benefited by the cancellation of the evidentiary hearing, and it was his family that benefited from the court's quashal of our subpoenas. That claim by a McCabe family member of a personal connection to this court has been the fodder, Your Honor, of myriad public comments and questions about this court's ability to maintain fairness over this particular proceeding. And if that weren't enough, the defense has just recently, received information that another witness, a seminal witness for the prosecution, by the name of Julie Nagel, who was Julie Nagel, N-A-G-E-L.
N-A-G-E-L.
Who was inside the house at 34 Fairview on the night of John O'Keefe's death.
Something out of the ordinary, like a black blob in the ground by the flagpole.
Apparently some 5 months after John's murder, and this is all public. We didn't have to do any digging and searching with subpoenas or otherwise. This was all public information. She used a Venmo app to pay for what appears to be a beach house rental, and the recipient on the Venmo payment reads Frank and Beverly. That is a public payment. It was there for all the world to see, and as soon as a reporter picked up on that, which is how we found out about it, and publicized that, she immediately took that payment down and took it off the internet. Your Honor, there has been an undeniable erosion of public confidence in this court's ability to be fair. But let me be very, very clear. The decision to recuse or disqualify a court due to the appearance of impartiality is not an indictment of this court's competence or integrity. It is not an indictment of this court's character. Nowhere close, and we do not aver that at all. Rather, the decision should be an expression of the unwavering commitment that this court has to justice, to fairness, to the rule of law.
I personally do not, nor have I ever had any questions, even a moment of pause in regard to this court's ability to be fair and impartial on this or any other case.
You wouldn't expect the person directly benefiting from unfairness to take issue with it being perpetuated inside this courtroom. Let's see what other valuable insights the Assistant District Attorney has to offer.
Whether the court, Your Honor, chooses to retain jurisdiction in this case, or passes to another judge to retain jurisdiction in this case, or passes from judge to judge as the judges rotate in and out of the session, really is of no consequence to the Commonwealth.
If it really is of no consequence to the Commonwealth, then why is Lally about to fervently argue against the defense's motion? He could have rested and said nothing at all. This is because he knows what's obvious to everyone paying attention, and that is the judge had been extremely favorable to the Commonwealth up until this point, and would continue to rule progressively more in their favor all the way through the first trial to this present day.
But what I would say is that, again, that operative term being reasonable, and the three sort of key things the counsel seems to want to hang their hat on, is essentially the first being some conversation between two individuals who have literally nothing to do with this case, who talk about this case in an online discussion. And there's a great many things that are said in that online discussion, but we seem to be focusing on just this one thing, and accepting this is true because this is what this person said. Whereas there are a great number of other sort of defamatory things that are said by this person, Mr. McCabe, in reference to this blogger. And we're not jumping to the conclusion that any of those things are true. I don't know whether they are or they aren't, but I'm just saying that we're focusing in on this one particular thing.
Let's be clear. The credibility of Sean McCabe's insults against the reporter are immaterial to whether or not there's an appearance of impartiality in this case. Once again, ADA Lally attempts to bring the focus back onto Turtle Boy.
From that attachment the counsel filed as far as that conversation, which is averred to be a true and accurate copy of that conversation, but it's not averred to be a complete transaction of that conversation.
Lally complains that the messages sent between Sean McCabe and Turtle Boy are not the complete record of the entire conversation. This coming from the same prosecutor who presented this screenshot allegedly showing Colin Albert's message to Ally McCabe requesting she pick him up from 34 Fairview Road, widely believed to be counterfeit, if not incomplete. And then there's this utter abortion of justice. But we'll save that for another time.
But from what's attached, I direct the court's attention to page 6, in which Mr. McCabe intimates in there that he doesn't really know anything about the case.
Lally continues to miss the point. If the McCabe family did indeed have an inappropriate relationship with the judge, how would Sean McCabe's level of knowledge of the case make a difference? It's completely irrelevant.
Okay.
Additionally, I would direct the court's attention to page 9, Well, I think it's pretty clear from there that the recipient of these communications, this blogger, doesn't even believe Mr. McCabe himself and his veheemence that he knows the court or is familiar with the court or has any influence over the court.
Whether Turtleboy himself personally believes Sean McCabe's statements or not does not affect the greater public's perception of impartiality.
And lastly, from that attachment, I direct the court's attention to page 11, in which it references earlier posts by this blogger about the judge. And that's, again...
Lally uses this opportunity to inform the judge that she herself has been the subject of Turtleboy's reporting, in case she wasn't aware.
I think we're looking at this divorced from the context in which this communication arises. This is not something that Mr. McCabe just generates out of his own head, as far as, along with a litany of other assertions that he makes in reference to this blogger, but it comes from prior posts and prior communications that were expressed by this blogger of already intimating impartiality by the court, just in reference to adverse rulings, which brings me to my second sort of underpinning of this motion, being that the court has, I guess, adversely ruled or denied motions that were filed by the defendant. I don't really see that as being any sort of valid basis for judges to recuse themselves. Otherwise, every time a judge denies a motion, then we're going to have to find a different judge because they don't agree with me. And in particular, they're pointing to a motion which had absolutely no basis in the rules of criminal procedure whatsoever as far as having an evidentiary hearing on a Rule 17 motion. And the third thing, as far as deviation from procedure of the Norfolk Superior Court, there are a number of cases that different judges might hold on to for a period of time. They might assign themselves to or be assigned to retain jurisdiction. And the court, hearing this motion or any other motions in this case going forward, regardless of whatever session Your Honor is assigned to, is really of no consequence, and it's really not anything that's out of the ordinary, as evidenced by the case that was called prior to this case, which is the trial that was conducted before Your Honor last November of a co-defendant. There's a scheduled trial date coming up in this November of the co-defendant from that prior trial. It's not an abnormal thing for this court or any court to do. For those reasons, again, I would pray upon the court as far as the decision is concerned, but as far as the Commonwealth is concerned, there's no request for the court to recuse themselves, and whatever judge hears the case is whatever judge hears the case. Thank you.
Do you want to respond, Mr. Jackson?
Very, very briefly. The only thing I would draw both the Commonwealth and the court's attention to is the person that made the statement, Sean McCabe, is related to Jennifer McCabe. He's a brother. He also didn't just throw sort of a dart at an empty dartboard. He hit the target because he made a claim that he had a personal relationship with this court, or at least his family had a personal relationship with this court. And that turned out to be at least some of the facts that he made, or that he claimed in the post, turned out to be true. And we've attached that. I'm going to be delicate about my comments here because it's sealed, and it should be sealed. That portion should be sealed or impounded. But it turns out that it's true, and the courts had access to, had an opportunity to see that. Also, with regard to the second post, it's also true in terms of the family members' names. It's not like they're just...
True what?
The family members' names.
Okay.
This court's family members' names, which I don't need to repeat here. But there is some fact-based information that troubled us because it turns out to be somewhat true. Now, the last thing that I'll say is that the Commonwealth's position was it may not be true. There's a bunch of invectives in that string of communications between the investigative reporter and Sean McCabe, and half that stuff may be true.
Jackson is about to advance the most important point of the entire hearing.
And Mr. Lally's words were, I don't know if they're true. And that's the point. He doesn't know if they're true. I don't know if they're true. I hope they're not true. I desperately hope that what Sean McCabe said is not true. But it doesn't matter what I think. It only matters what the public perceives might be the case. And the word might is in the rule. It doesn't have to be the case. But a reasonable person looking at this from the outside looking in, if they're disinterested, might they think that the court has some relationship that would compromise the court's ability to be fair. That's enough, and at that point it triggers this court's requirement to disqualify itself. That's all. We're not suggesting that the court is not fair, nor impartial. Nor partial. We're suggesting that the public may perceive it that way, and they reasonably have perceived it that way. And I'll see you.
Okay. It's 2:35. I'm going to take a 20-minute break to consider what I've heard here today. Obviously, I've read everything in advance. But let's
Thank you.
All right.
While Judge Cannoni is taking 15 minutes to deliberate on the recusal, let us take a moment to assess whether there was substantive evidence indicating that the public perception of this case was genuinely declining. This was happening right outside on the steps.
You are unmuted.
So I appreciate the arguments of counsel. I've considered those arguments. I've considered the pleadings, the motion, the attached affidavits, the big pack of attachments to the motions. I've considered those placards that were shown here today. A couple of them I hadn't seen before. So the defendant raises 4 discussion points in their motion. There's some claim delay in my rendering decisions. There's dissatisfaction with adverse rulings and alleged impropriety of retaining jurisdiction. But notably, there's some allegation that I have some relationship with a man named Sean McCabe, and that therefore I have a connection to this case, and therefore I have a bias in favor of the Commonwealth.
Strawmanning refers to a type of argumentative tactic where someone misrepresents or oversimplifies their opponent's position to make it easier to refute. Alan Jackson went to great lengths to make it clear that his concern was the perception of partiality by a disinterested public. But it's much easier for Judge Cannoni to pretend she's been accused of being biased herself and then deny it.
That simply is not the truth. I can assure all parties that I don't know Sean McCabe. As far as I know, I have never spoken to him or had any contact with him.
She said she doesn't know them. No fucking.
I've never interacted with him, and I certainly never have socialized with him or with any family members or any witnesses whose names have been said here.
That may be true, but what about Michael Morrissey? Besides Karen Reed, he may have the most riding on the outcome of this case. Him and this judge are around the same age. Both grew up in Quincy and have both been working within the Massachusetts legal system for decades. We know that the judge's mother was employed by Morrissey's wife for years back in the 1990s. How well they know each other and when they last communicated remains as lingering questions, yet to be answered. But how could that possibly work? Well, he would need a judge in his corner, someone willing to stay on the case instead of rotating off. A judge who wouldn't raise an eyebrow when tampered evidence appeared on the screen, wouldn't question which trooper was assigned to manage the jury, or ask how the 3 most pro-Karen jurors were suddenly eliminated at the last minute. Not in on the cover-up, just willing to look the other way. What is your perception of this court? Please let us know in the comments.
Always been ambitious to move this way.
Trooper Proctor has a sister who has a friend who has a sister who has a husband who has a brother who has a wife who has a sister who is Jennifer McKay.
Close friends.
That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance. It's around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior. If he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy? Or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy?
She's fucked.
Where's your brother? Kevin.
I didn't do anything wrong in this.
If they're all in the house, Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead.
I was against it.
Then why do they all testify that no one came into the house?
Peace of the world.
We'd like to ask you some questions.
And as governor, I am disgusted.
You guys made that?
I'm not on your lawn, I'm on the street.
How long did that hold?
CUNT. Declaring mistrial.
Taylor is correct and Johnson is polarized. You think your actions impacted the outcome of the trial? We're all on the same joke, right?
Find ourselves at an impasse.
It's our responsibility at the U.S. Attorney's Office to investigate allegations of public corruption.
Open internal affairs investigation.
There's a kind of backwards.
Your service is complete. I'm declaring mistrial in this case.
Shame on us.